Many times people have deportation orders and they are married to citizens and they want to know if they can get legal. In general, if you have a deportation order, the only way to get legal would be to reopen your deportation case. But you're not eligible for a green card even if you reopen your deportation case if you didn't enter the United States with a visa. So in those circumstances, the deportation order might not be able to be fixed. There is something called a provisional waiver for people who have final orders of deportation, which is somewhat new. You would have to then apply for an I-212 waiver, which would waive the deportation order. And that waiver is done here in the United States. If that I-212 waiver is granted, and then you need to apply for another waiver of the 3 and 10-year bar, which is an I601A waiver. So if you're in the U.S. illegally and you've been here for more than a year illegally and you leave, you can't come back for 10 years. So the I601A waiver is going to fix that ground of inadmissibility for the 3 and 10-year bar. If your I-212 waiver is granted, which is the waiver of the deportation, and your 601A waiver is granted, which is the waiver of the 10-year bar, then you would go back home to your U.S. consulate and apply for a visa there, hopefully be there for only a few weeks, and then come back to the United States with a green card. It's important to know that not everybody who has a deportation order is eligible for the waiver, and it's important to talk to an immigration lawyer about whether you fit the criteria.